There are many different ways other than litigation to resolve a high asset divorce case. Let's say you have a divorce case where the parties cannot come to an agreement through mediation, but there are reasons why they cannot or should not proceed to trial. Perhaps this case involves Sheridan issues, where there are unreported income or other matters that, if brought before the court, will expose both or one party to the Internal Revenue Service or even criminal problems. In a situation like this, the parties agree to keep the case out of the court system and they proceed to arbitration. Now, under this method, an expert such as a retired judge or a highly skilled attorney is hired to act as a judge and hear the case just as if it were being presented in a courtroom, but in a neutral site such as a law office. People are sworn in under oath. Many times there are transcripts taken, and the arbitrator or acting judge can make binding decisions. Arbitration is actually a good way to go, as opposed to going to litigation. It's more expeditious, and it's usually less costly. One problem with arbitration is that you don't have the same rights to the appeal process as you do when you litigate. However, we are now resolving those issues because many experienced arbitrators will allow the parties to go to an acting appellate court, which is actually chosen before we start the arbitration process. Perhaps 2 or 3 retired judges or experienced lawyers are selected to fill that role, and if appeal is filed, they will then act on the arbitrator's decision. Arbitration and mediation are becoming more prevalent in divorces. People are leaning more towards them these days, especially after they hear all the horror stories of how long and costly litigated divorce cases can be.